a second. Wait. So I want to just make, did the prosecution call Ms. Calgar in that case?
No,
No,
Your
I
Honor.
did, Your Honor.
Wait a minute. So you're representing the husband and you call the wife who then testifies without being, where was this at? Was this in our courthouse too?
Yes,
Your
with
Honor.
Judge Hudson.
So then Ms. Calgar made incriminating statements? Is that what happened?
Yes, Your Honor.
Your Honor, I disagree that she said anything incriminating.
Well, wait a minute. Can you tell me, Ms. Cahalan? You were on that case, right?
Yes, Your Honor.
What did she state under oath to pay?
Yeah, that's what she told me to zoom in for, to get a different payment plan. My job that I just got pays every 2 weeks, and obviously my
Just
first
slow
check.
down a second. Let's just slow down a second, okay?
Okay.
I sentenced you on March 19th and you were to pay 50 per week beginning April 27th. I'm just on the disorderly person case.
Yes.
Okay, so you paid $100 on March 19th, which that was the order, and so you're about a week late on this one, right?
Yes.
All right, let me check the other two here. So I entered the conviction on the furnishing or selling alcohol to a minor from May 15 to 25. I did that on March 19th of 26. I told you to serve 20 hours of community service by June 1 on that, right?
Yeah, those two cases you
Okay,
gave me.
right. Okay. So then on the other one, I gave you time to perform community service 25 hours by July 15th to 26. That's on the open intox, right?
Yes.
Okay, so now you want to extend your time to pay just on this one case, correct?
Yes, just to get a different payment plan.
Just
And
tell me what you want.
so I get paid on the 8th, and then I can pay 50 then, and then I was just gonna see, is it possible maybe 40 when I get paid each week,
You get
every
paid-
2 weeks.
You just pay $40 bi-weekly. How's that? We'll start at beginning. I'll start you next Monday, okay, on May the 11th. Fair enough?
Yes, that sounds perfect. Thank you. I just wanted to ask so I didn't get in trouble, and I know you
No,
rather people
just-
ask.
I'm just glad you came in and asked me. You're a little late. Next time, do it timely though, okay?
No problem, sir.
And everybody out there, we have these public satisfaction surveys. If you wouldn't mind filling it out, the Supreme Court has us doing this. So whatever, if you have time, I'd appreciate it. Everybody who's going to be on Zoom today, okay? Or anybody out here. All right, you're all set, ma'am. I wish you well. Good luck. If you need more time, don't worry about it. Just call on her before the due date. I'll give you an extension, all right?
Thank you so much.
Have a good day. Good luck.
You too.
Okay, anything else down there that I have? What do you have in the front row, ma'am?
My lawyer is late.
They're waiting on the lawyers.
You guys waiting on a lawyer too?
What was your name again? Nicholas Powers. Yeah, this file's be up there. Powers.
Yeah, I don't have powers. Did you call your lawyer?
Yes,
Yes.
she said, I'm scheduled for 10 o'clock.
Oh, you're not scheduled till 10?
Yeah, I was here at 8:30, because that's what my paperwork said.
What time are you scheduled in the front row there, ma'am?
Right now, I'm texting him.
Where's your lawyer?
Thomas Courts. Is he already here?
I haven't seen him, so yeah, tell him I'm ready. I'm sitting here, ready to go. When I was a judge or a lawyer, I waited for the judges. Now I wait for the lawyers, it seems like. Go figure.
Sorry.
It's all right. It's not your fault. What's that?
I don't hold it against them.
No.
I'm just kidding.
What is Mr. Powers having here?
Yeah,
Where's that file?
I don't know. John, And that's Lisa.
Good morning, Mrs. Morrow. How are you?
How are you?
Good. You're here all bright-eyed and bushy-tailed this morning.
Welcome back to state day, right?
I'm looking forward to it.
Sorry,
really am.
here at the same time. More exercise, more walking. It's okay.
Nicholas Lynn Powers?
Yes.
Come on up here. Yeah, you need to go in and talk to the prosecutor right now. You don't have a lawyer, right? This is a
Yeah,
pre-formal.
that's what I asked.
Well, this is a pre-formal. This is a pre-formal. So you go right outside. Pre-formals, they gotta talk to them whether they're in.
I'm doing whatever.
Okay, go right out in the hallway and they'll call you right in, okay? All right, people against, Holland Logistics. Holland Logistics LLC, 26S118410. Okay, I'm gonna need Holland Logistics in here, to state your name. Your name, ma'am. I can't have the office manager on these.
Oh shoot. Well, let me put him in. I don't know how to join him.
What's your name?
My name is Leanne
Leanne what?
Harris.
You gotta get the president in here. Can you get the president to zoom in? Can you come in here, Ms. Esmaro?
Yes, I can. One moment, please.
Thank you. So your appearance, please. This is Holland Logistics.
Good morning, Robin. How can you have people behave when I do?
So as you know, I can't let a non-lawyer, even if it's the president, represent a company on a misdemeanor. On civil infractions, I don't mind bending the rule ever so slightly, but they gotta at least have the president here. So not office managers.
Okay.
So at least the president. It's preferable, frankly, for a lawyer, but I can look I can justify this in my mind on a civil infraction as long as the president or a vice president or officer is here. I can't have an office manager. Have you called them? Is the president gonna show up?
Yes, he's on the phone. He just was driving, so unable to join into the phone
Have
Zoom.
him pull over and join, and you
Okay.
give him the number and have him pump in Holland Logistics in his name. And I
Okay.
will call the case then, okay? So
Okay,
I'll just
thank-
ask in the future that you just make sure it's an officer of the corporation on a
Yes.
civil infraction. No officers on misdemeanors. I can't let that happen. Okay?
Okay. Okay,
Thanks.
thank you.
Thank you. Franklin Quint, I'm sorry, Nicholas Quinn Frank, sorry, 260-240400. Your name?
Nicholas Frank.
All right, you're gonna plead to fishing with more lines in the water, right? More than two lines in the water, right? It's a civil infraction.
Yes.
And then they're gonna dismiss the misdemeanor, then that's thrown out for you, okay? Fair enough? Is that what you want to do?
Yeah.
To that charge under section 32448-738, how do you plead to that charge, fishing with more than two lines in the water? Responsible, it's a responsible plea. Okay. I'll accept your plea. You have a license now?
Yeah.
Can I see it?
Yep.
I'll believe it. I'll believe you.
That's my phone now.
That's all right. I'll believe you. $140. Okay? Go right down the hall. Just make sure you have a license from now on. Will you please? Have a good day. 140 is your total. Thank you. I hope they're reminding them down there to fill out those surveys. Lisa, would you call down to the desk and make sure they're inviting people to do that, so we have some sample sizes? How you doing, Mr.?
Doing great. How are you, Judge?
Good, we'll have to talk in a second. Do you have a file ready for me? Is that the sentencing Madrigal?
Yes.
Okay. All right. Give me 1 second here, please. People against Alexander Madrigal, file number 26G306740B. That's the impaired charge. And then I'm also calling the A file, which was a plea to impeding. Your appearance? Sir, your name?
Alexander.
All right, your client pled to impeding traffic on the civil infraction. The speeding was dismissed. He also pled to operating while impaired with the OWI to be dismissed. He was referred for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
The report is accurate, no corrections.
Anything that you would like to say?
That's the matter for this type of matters. Unremarkable, Mr. Madrigal has no prior criminal records, 34 years old. He's employed. The test results were 0.11, relatively low end for this type of event. We would ask the court to consider this last and us.
No probation.
Good, that's where the legislature's at on this right now.
They're awful nice. I knew you were going to ask that on this one, and I can't let my fundamental differences get in the way, so I don't disagree with you. Anything you'd like to say, sir? I mean, he's going to do some community service and that type of thing, but I'm not going to place you on probation. Anything you'd like to say, sir?
No, thank you. It's here.
I don't agree with it, but you know what? It doesn't matter what I think. All right. I want you to attend the victims impact panel. That is one night put on by Mothers Against Drunk Drivers, okay? I'm going to order 3 days jail credit, 1 served to let you serve those by way of community service, 16 hours community service. He's right. I cannot find a substantial reason, any reason really, to place you on probation in light of that legislation. So I'm going to go 300 fines, 450 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $875. Screening fee is $60 for $935. You have attorney fees of $40. I'm gonna go light on that, $975, and then $166.57 on the cost of recovery. So that should be $1,075, $1,135, $1,140, $157 on that. Lisa, will you double check that? So you're going to pay $1,140, $157. You're going to do 2 days of community service, which I'm going to give you until June 20th to pay. And 1 day on the victims. Oh, you're going to go to one night victims impact panel. And then I'm going to order $150 on the impeding. So you have a total here of $150, you have $1,290, $157. Can you pay that today? Or do you need time? How much do you have today?
I think Mother's Health need to pay, but I'm not sure.
Well, can you pay the impeding today? That's $150.
Yes, sir.
Can you pay anything more than that today?
Yes, sir.
How much more?
Probably all of it.
You sure?
Yes.
Okay, your mom's gonna help you out. All right, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I wish you well. You're still gonna meet with probation. They're gonna set you up, help you set up the victim feedback panel, okay? And tell you where you can do your community service. I wish you well. Good luck. No more though. They're never gonna be this easy again. You understand what I'm saying? You ought to write a letter to the legislature and thank them. Have a good day. Thank you, Mr. Higgins. Good luck, sir. Thank you, man.
Thank you, sir.
All right. Do I have Holland's Logistics president here yet or not?
Yes, he's
I have a-
in.
I have a Motorola that I can't identify.
No, it
We'll
should
see.
say, what is your name on there?
He's got to put his,
His should say Holland Logistics.
Honorable Michael K. McNally's personal meeting room. Host has joined. We'll let them know.
there.
You're
Is
here.
that the Motorola G?
No,
No, this is a iPhone.
Okay, hang on.
Is your name Cedric?
yes.
Okay, I got it.
All right, people against Holland Logistics, 6S118410. Mr. Cedric, there you are. State your name to me, will you please?
Yes, Cedric Holland.
Okay, so you're the president of Holland Logistics, correct?
Correct.
And as I understand it, this has been negotiated where you're gonna, the company's agreed to plead responsible to overweight with agreed upon fines and costs of $1,900. Is that right?
Yes, sir.
And then you're gonna have 30 days to pay. Do you agree to that?
Yes.
On behalf of the company to the charge of overweight, responsible or not responsible?
Responsible.
Okay, I'm gonna accept the plea. I'll give you until I'll just make it June the 8th for you, $1,900, okay?
Okay.
If you don't have the money, sir, call the court and we'll give you an extension. I'll talk to you online, all right?
Okay, can I ask a question?
Sure.
Can we start making payments as of today towards the 1,900 or have to be paid in one lump sum?
Yeah, you can start paying it all now.
Okay.
Is that what you mean?
Yes.
You still gonna be able to have it paid in 30 days?
That's why I want to start paying today. If I can start paying today in 30 days.
I'll tell you what I'll do.
Yes,
Listen
sir.
to me. I can give you more time. Here's what I'm gonna say to you, okay?
Okay.
You pay $300 due each week, okay?
Okay.
And I'll have you make your first payment beginning on Monday, which is May the 11th, all right?
Okay.
So you're gonna get about 7 weeks roughly to pay that.
Not a problem. I appreciate that.
And then if you need more time or you don't have the 300 on any Monday thereafter, you call the court, we'll go on Zoom, okay?
Appreciate it.
All right, and appreciate if you'd fill out that survey. They want us to have, the Supreme Court wants us to have the surveys completed. There's a public satisfaction survey. If you have time, I'd appreciate it. If you don't,
Yes. No
worries.
Listen, that's the least we can do.
no worries. Good luck. Thank you. Austin James
Thank you.
Messick, 26M676-763. I don't, is he?
He's on Zoom's coming.
Oh, okay. The officer's not here, right?
Not see the.
All right, where's Austin Messick?
Right here.
Okay, you have to start your video, sir.
I apologize.
It's all right. Okay, Mr. Messick, tell me your name.
Austin Messick.
All right. You got a valid plate now?
Yeah, it just got sent to me 2 days ago.
Case dismissed. The officer failed to appear. I gave him 15 minutes. It's now 21 or 2 minutes into it. You're all set.
I appreciate it.
Your Honor, Detective Lieutenant Chris Rembes, Flat Rock Police Department.
Thank you. So, ma'am, do you understand that you have the right to a preliminary examination within 7 days of the date of the probable cause conference, but that your lawyer wants an adjournment until the 19th, which means that preliminary exam would not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, Your Honor.
Do you waive that right, knowing that your lawyer wants more time to prepare?
Yes, Your Honor.
All right. I'm going to go ahead and adjourn the preliminary examination. We're going to make it May the 19th. And that is going to be we'll make it at 10 o'clock. How's that, Ms. Belcher?
That's good, Your Honor. That's the day you're coming in late. So we're starting at 9:45.
Oh, so I need to make it a little later, you mean?
Yes.
Right, okay. Why don't we make it 10:45? Is that good, Lisa?
Yeah, that's good.
10:45, Ms. Belcher, okay?
Yes, Your Honor.
Anything else? You said you want to bring up a condition of bond, and that is what?
Yes, Your Honor. As a condition of bond, my client was not to return to the address. The complaining witness was at the time a neighbor, so my client's been unable to return to her apartment with her minor child. I did speak with the prosecuting attorney on this file. The victim's advocate, Ms. Dodge, spoke with the complaining witness and confirmed she's no longer at that apartment complex. She was evicted, I believe, on the 30th of last month. So we're asking for that condition to be lifted so that my client can return knowing that the complaining witness is no longer next door.
Okay. Call in the prosecutor, will you, John? 249. All right. So you want the bond modified so the defendant can return, to 25811 Valley Creek Drive, correct?
That is correct.
And the prosecutor, I'm just going to confirm that she's agreeing to that for that reason, so as to permit the to return to 25811. Ms. Asmaro, your name? I certainly have no reason at all to doubt Ms. Belcher's word, but she's saying if you guys agree to a bond modification, you can write it right on here, and then I don't have to bother you, okay? But you were agreeing that the defendant can return to her residence at 25811 Valley Creek Drive, apartment 1112, because the
Yes.
victim has left the residence next door, right?
She speaks to the victim in the case, and she did say that she's no longer at that residence. And I apologize, that was my fault. I was supposed to.
That's all right. I'm gonna go ahead and order that. I'll allow you to return there, ma'am. And that is apartment 1112, correct? For whatever reason, there's a little discrepancy on this file. Is that right, ma'am?
No, I live in apartment 1111. She lived in apartment 1112.
Yeah, that's okay. So you can go back to that apartment, 1111 at 25811 Valley Creek Drive.
Thank
you. You can do that today. Anything else, Ms. Belcher?
No, Your Honor.
Have a great day, Ms. Belcher. Thank you.
Judge. You too.
Now, Scarina, Jesse James Scarina, 23F712753.
That's Mr. Gonix. He's in a breakout room with another client, and Scarina is the one that's coming in person.
Okay, Philip Conklin. Is Philip Conklin ready to go here? Philip Russell Conklin.
That's also Mr. Gonix. He's in a breakout room with him.
Okay, so he has Scarina and he has Conklin. Okay, good enough. Do I have Camille Hamzi Awad?
Yes, Your Honor, that's me.
Okay, that's 260-240-064. Sir, your name?
Camilla Wad.
All right, so they're going to go ahead and dismiss this. Right?
Yes, Your Honor.
Did you have a fishing license?
Yes, Your Honor, I did.
Okay, good enough. So the prosecutor's satisfied. Case dismissed. Again, everybody out there, the Supreme Court wants us to have this public satisfaction survey. So if you could take a minute, we'd appreciate it. If not, I understand. Who else do I have besides You're all set, sir. Your case is dismissed.
All right, thank you so much, Your Honor.
Thank you. All right, so what do I have now? I'm waiting on Mr. Gonick for Conklin and Scarina, right?
I think that, excuse me, I think they're ready on Cowger also. That was a special prosecutor.
Good morning. How are you? Good. All right.
Miss
Which
David,
one is-
Tucker Davis, do you need to speak to your client?
Is he there, Lisa?
Yes,
Which
he is.
one? Ms. Lussell, is that your case with the special prosecutor?
Yes.
And that defendant's name is?
Chowger?
Do we have that one?
Your Honor,
Richard
I'm the
Slaughter.
prosecutor on Cowger, although I believe that it's Attorney Ben Gonick's case.
I filed my appearance this morning.
Conklin and Scarina here. I'm waiting on Mr. Scarina. Are you Mr.
He just
Scarina?
walked in.
Okay, good enough. Well, as soon as your lawyer comes out of the breakout room, I'll call that, okay? Nicole Savage. Nicole Gwen Savage. This is 26I-706-855.
Good morning, Judge. Attorney Thomas, Court of Peace 77177, appeared on behalf of the defendant. Ma'am, can you state your name for the record, please?
Nicole Glenn Savage.
So these are just recommendations. I need to confirm that with her. With the prosecutor. So what prosecutor were you dealing with?
I believe Nora, Your Honor.
Oh, yeah, Ms. Holloway. I want to need Ms. Holloway in here. All right, so I have a stipulated plea agreement here, ma'am, that says that she is going to plead. Correct me if I'm wrong.
Good morning, Your Honor. Do you want my name on the record?
I do.
6528.
I'm a little. Give me 1 second, will you please both? First of all, I want to just confirm that this is when you say batters counseling, that's a 26-week batters program. I don't know whether this merits that or not. I don't know anything about the case, but I think we had this arrangement before.
I apologize. I did not put prosecutor recommends on the form, but just to be clear for the record, that is a recommendation. So if the court has a different domestic program that it deems more appropriate, I would have no objection to that.
All right, so these are recommended. It's not part of a sentence agreement, correct? Now, she had something in 2019. Lisa, I'd like you to check that was assaultive in nature. Did you see that?
I did, Your Honor. I did review the file back when I offered his plea offer. I don't recall exactly what that
It was assault or assault and battery, and it says dismiss, which makes me think it was taken under section 771.1. And that
It was, Judge.
So when you
Yeah, it doesn't clarify that for me, but I take a look at it and.
Well, you can count on that whenever there's a dismissal with fines and costs. Back 30 years ago, it was all right to dismiss upon payment of fines and costs, and they did. There was no problem. And then the language changed. We cannot dismiss a case upon payment of fines and costs. So now the question is whether or not she qualifies under 7694A. When an individual has not been convicted previously of an assaultive crime, pleads guilty to or is found guilty of a violation of this section, that she qualifies. Because she really was convicted and then it was dismissed. My understanding is if there's a previous assault conviction or plea that you can't take it under 7694A. If you guys want to talk about it further, Mr. Courts, I'll be glad to let you do that.
Yeah, if you wouldn't mind, I apologize. Could we have a slight adjournment then? So
I don't have an issue with that.
I have a problem, Your Honor.
This case has been going on though. So I'm gonna just adjourn it 1 week, okay?
Yeah.
You can be available next week, May 12th?
Yes, Judge, I'll make it.
8:30?
Yes, Judge.
I'll be on this bench. 8:30, okay, ma'am? You're gonna go down the hall and get your notice. Thank you. Do I have any of these other felonies ready?
Yes, Your Honor, the people are ready on Cowger.
I don't have Calder.
Judge, it might still be with the prosecutor because it had a special prosecutor. It might have went in with Miss Esmaro by mistake.
Let's take, can you go check, John? Steve Sterling, Joseph Wright. Let's take that, 26B-703-678. Ms. Tucker, are you ready?
She's in a breakout room. Mr. Gonick is here.
Okay, people against Philip Russell Conklin, 26R-705-091 and 25R-713371. Good morning, Mr. Gonick. Your appearance?
Good morning, Your Honor. Ben Gonick on behalf of Mr. Conklin for both files.
Okay, where is Mr. Conklin?
He was in the Wayne County Jail. I just met with him in a breakout room. He should have come back in the main room.
He's in Oakland. I just brought him
okay.
back in.
Okay.
Okay. Mr. Conklin, tell me your name, please.
I don't know why they would have taken him back.
Either. Mr. Gonick, did you talk to him about the fact that you were asking for an adjournment?
Yes.
There it is. There it is. Mr.
Yep.
Conklin, your name?
Philip Russell Conklin.
I'm sorry, what's your name?
Philip Russell Conklin.
This isn't the guy, right?
Yeah, it is.
I'm hearing, are you Mr. Conklin?
Yes.
I'm having a hard time hearing you. Can you get closer to the device and keep your voice up, please? State
Philip
your
Russell
name
Conklin.
again.
Philip Russell Conklin.
Okay, that's better. So your lawyer's asking me to adjourn this case, the PCC, it looks like, from the STIP for a week to May the 12th, and then the preliminary examination to May the 19th. Do you agree to that?
Yes, I do.
All right, so what time are we going to do on the 12th, Lisa? At 9:30, is that okay?
Yes, 9:30,
And then what about on the 19th?
11 o'clock.
11 a.m. sharp. Okay, so we'll see you next week. So that's what we're doing. May the 12th and May the 19th. So your PCC will be next week. Your preliminary exam will be the following week. And we will see you here next week at 9:30 and then at 11 o'clock in the morning if it goes that far on the 19th. Okay?
Okay, thank you.
Any questions?
No, that's it.
All right, you're all set. Anything else on that, Mr. Gonick?
No, sir.
Thank you. Mr. Scarina has the OWI 3, correct? There's just one file, right? And that's yours?
Correct.
Come on up here, sir. Jesse James Scarina, 23F 712-753. Your name?
Jesse James Scarina.
All right, Mr. Gonick.
Your Honor, I was Ben Gonick for Mr. Scarina. Your Honor, I was appointed to him late last night, and they didn't give me any contact information for him. And I guess I need some contact information so I can talk to him about his case. But in the meantime, I don't have any discovery, so I was going to request an adjournment of the PCC for a week, and then do the same thing that we did with Mr. Conklin, have the exam, a week later.
Do you feel comfortable him stating his phone number on record, or do you want him to do it some other way?
Whatever he feels comfortable with.
What do you feel comfortable with?
It's okay either way, but I don't know my own phone number.
Well, your lawyer has to be able to get a hold of you.
My aunt might have to write it down. I got my phone with me, but I don't know how to look it up on the phone. I'm not computer smart.
Well, that's okay. Listen, Mr. Gonick, I'm going to give him your number. Would you repeat your number to me for him, please?
Sure. 313-574-3355.
So why don't you go out and call Mr. Gonick right when we conclude with this? Are you available, or you want me to call you?
Oh, yeah,
later?
no. Tell him to get, that's all. That'd be great, Judge.
So I'm going to give you this sticker. It's got his phone number on there, and you go call him as soon as you get your paperwork. He's telling me he just got appointed. He wants to be able to talk to you. He needs to talk to you so you can prepare a defense here, okay? So I'm gonna go ahead and adjourn this a week on the PCC, May 12th at, what are we gonna do? What did I give you on the other one, 9:30?
Yes, sir.
We'll make it 9:30 and then I'll make your preliminary exam on the 19th at 11, okay?
Okay.
So you go call him right now, but first go down the hall. We're gonna give you a paper notice. Do you understand that?
Yes, sir.
You are all set. Thank you.
Thank you, Your Honor. Have a nice day.
Thanks. Hey, you too, Mr. Gonick. Take care. Thank you. Is Sterling Wright ready with Ms. Tucker Davis?
Breakout room.
Okay, now I've got Cowger. Stephanie Nicole Cowger. 26B 709-107. Okay, so you entered an appearance on this, Ms. Schlussel?
Yes.
Okay, your appearance?
Deborah Schlussel, P56420, on behalf of the defendant, Ms. Stephanie Cowger. Ms. Cowger, please state your name.
She's not
I'm
out
bringing
there.
her in. I'm bringing her in right now.
Okay.
Sorry, Your Honor.
That's all right. Not a problem. Okay, ma'am, you have to unmute and tell me your name, please. There you go.
Stephanie Cowger.
All right, so your lawyer has just stated her appearance. You posted your bond, and we have a PCC scheduled for today and a preliminary exam for the 12th. Did you already talk to the prosecutor on this one, Ms. Schlussel?
Your Honor, may I make a record of something real quick?
Sure, I'm sorry. Ms.
That's okay.
Cahalan, your name, my apology.
That's okay. Claire Cahalan, on behalf of the people, P88772.
Who are you related to?
All of them. All the Cahalans that you're thinking of.
You'll probably be a judge someday. Don't move down here and run against me, okay? All right, go ahead. What do you want to say?
So the defendant in this case is charged due to a matter that occurred with her husband. And that case, he was charged with multiple counts of criminal sexual conduct. Those cases are intrinsically connected and intertwined. And so the dad's preliminary examination was held on the 30th of April. And before dad's preliminary examination, attorney Deborah Schlussel told me that she would be representing mom. But however, mom testified in that examination. She was not read her rights before she testified. There has been no record made of whether both the defendant in this case, Miss Stephanie Cowger, and the defendant in the dad's case, Christopher Cowger, waived that conflict of interest, because there is a huge and extremely severe conflict of interest in this case here.
So you represented the husband too, Ms. Schlussel?
Correct. Your Honor, they have a unified defense, and Ms. Cowger waives any conflict of interest.
Your Honor,
Well,
she has to
wait
do
a
it on.
second. Wait. So I want to just make, did the prosecution call Ms. Cowger in that case?
No,
No,
Your
I
Honor.
did, Your Honor.
Wait a minute. So you're representing the husband and you call the wife, who then testifies without being, where was this at? Was this in our courthouse too?
Yes,
Your Honor.
So then Ms. Cowger made incriminating statements? Is that what happened?
Yes, Your Honor.
Your Honor, I disagree that she said anything incriminating.
Well, wait a minute. Can you tell me, Ms. Cahalan? You were on that case, right?
Yes, Your Honor.
What did she state under oath?
Your Honor.
Just generally speaking, summarizing.
Yes, Your Honor. She stated completely opposite of what her statement was to the police in her interrogation when she was under oath. So they completely are opposite from one another regarding her case.
All right, so be more specific. She told the police what during her interrogation?
She told the police during her interrogation that she had witnessed certain things and had been told about certain things about the sexual misconduct that was going on, and then under oath testified to not witnessing this and not actually being told, only being told very briefly about some things.
Your Honor, if I may respond, Ms. Cowger stated on the record that she never said those things to the police and that the police got it wrong.
Your Honor, that's not true. I have video cam of the entire interrogation, which has been sent over to Miss Debbie Schlussel.
I don't know how you can represent her. I don't care if she waives the conflict or not. That's only part of it.
Your Honor, then if the court requires, I will withdraw from representation of Ms. Cowger and she can go back to Mr. Gonick the court prefers that.
I mean, I will be happy to allow you a week if you want to brief this, but it certainly sounds to me like there's a conflict. I'm not going to make a haphazard guess here, but it certainly sounds to me like there is. And if there is, for your protection too, I don't think you should be involved in this case. But that's my feeling. If you want to brief it, but again, I wasn't there. I didn't handle that case. It'd be a lot easier if I was the presiding judge on that case, but I wasn't. So if you want to brief it, Ms. Schlussel, I don't want to deny her who she wants to represent her, but I have to. I have to when there's a conflict here. So if you want to brief it, I'll give you a few days, but I do want to move this along. Do you want to brief it and tell me why there's no conflict and the prosecutor can file a brief and they can provide excerpts? Do you have the transcript yet, Ms. Cahalan?
No, we don't, Your Honor. We're waiting on one. Been
Your Honor,
will request it.
Your Honor, given the statements that have been made by Ms. Cahalan and the court, even though I dispute what Ms. Cahalan is saying, I don't want to create any issues for myself or, more importantly, for Ms. Cowger. So I will withdraw my representation and she, I believe, will want to seek a court appointed or another counsel.
I want to be clear. I'm only saying at this point, it certainly sounds like there's a conflict of interest. If you think differently, you can file a brief. If you don't think differently, or at least feel that it's in the best interest of Ms. Cowger for you to withdraw, then that's certainly your prerogative. I'm going to let you go into a breakout room, I think, and discuss it with Ms. Cowger, and then you can come back and tell me which of the options you choose.
Okay.
And if you do choose to withdraw, then we're going to go back and have Mr. Gonick, I think, reappointed on this, Lisa, okay? So why don't you take a few minutes and talk to Ms. Cowger, and then you can come back in and tell me what your position is, okay?
Okay, thank you.
Thank you.
Thank you,
Do
Your
you have
Honor.
another case here, Ms. Caitlin, or just this one?
Just this one, Your Honor.
All right, thank you. I'll just ask you to be patient while she does that,
Of
okay?
course. Yes, of course. Thank you.
Thank you. Stephen Joseph Wright, 26B703678.
May it please this honorable court, Don Tucker Davis representing Mr. Sterling Joseph Wright, who is present on Zoom with his permission, Your Honor.
Morning, Mr. Wright, and good morning to you too, Ms. Tucker Davis. Your name, Mr. Wright? I didn't hear you.
Sterling Wright.
Okay, so your lawyer, you want to adjourn the PCC for a week, right?
Yes, would you
And
like
the exam for 2 weeks. So we'll give you May the 12th at 9:30. And I'll give you May the 19th for the preliminary exam. We going to do 11 still, Lisa?
Yes.
At 11 a.m. So the PCC will be 1 week from today at 9:30. And the preliminary exam will be May 19th at 11. Okay, Mr. Wright, do you have any objection to that at all, sir? I didn't hear you. I don't know why I'm having
No, Your Honor. No.
Okay, thank you. Do you have any questions for me? I don't want you to talk about the case much at all, really. I just want to know if you have any questions.
Not as of right now, no.
Okay, thanks, Ms. Davis. Anything else?
That'd be all. Thank you, Your Honor.
Have a great day. Thank you very much. Good luck, sir.
Thank you.
Judge, I think the civil case is ready also.
Okay, that's gonna take a minute too, I think. So let me try to get through some of these other ones real quick. Christopher Michael, Heb Street, 26W 709520. Good morning.
Good morning, Judge and staff. John Graziani, P number 43387, on behalf of Mr. Christopher.
How are you doing, Mr. Graziani?
Please identify yourself, sir.
Good to see you again. You want an adjournment?
That's correct.
How many
Judge.
weeks? 2?
2 weeks I prefer, Judge.
We'll adjourn to May the 19th, Lisa, at
10:30.
10:30.
Thank you, Judge.
Okay, anything else, Mr. Graziani?
Are there any questions on the judge, particularly with regard to your son? Is he in custody of your ex-wife? Yes. Okay. Has there been any contact? No. Okay, so you're gonna have to continue on with the court orders. Okay.
Okay.
Anything else, Judge?
No, not at all. Thank you very much. Sir, go down the hall and get your notice, please. Okay, Stephen Brian Goodman. This is 26T724321.
John Graziani, on behalf of Stephen Goodman, Mr. Goodman is standing to my left. Please identify yourself, sir. Stephen Goodman, Jr.
May 19th?
Yes, Judge.
He wants an adjournment on this one, so I'll do the same thing. May 19th at 10:30, right? Isn't that the time I gave him on the other one?
Yes, sir.
Yes.
That's what I'll do, May the 19th. Thank you very much.
I'll be back there shortly.
Thank you.
Stay in touch.
Is Ms. Cowgar out yet? And Ms. Schlessel or not?
No, they're still in a breakout room.
Lisa, she filed an appearance, right?
Yes, this morning.
All right. I'm gonna have her, well, we'll see what she says. All right, let's bring the lawyers in on the civil case, which I do not have, by the way, Jennifer Weisman.
Yeah, you do.
I do? Oh, I do. Okay, I'm sorry. I keep forgetting I don't have file folders on these. Trenton Associates versus Twin Bridge Enterprises, Inc., 2601067. Good morning, gentlemen. Mr. Harris, your appearance?
Good morning, Judge Dennis Harris, P 35791, appearing on behalf of Trenton Associates LP.
And good morning, Your Honor, Attorney Angelo D'Onofrio, P 81836, on behalf of the defendant and the moving party in this matter.
All right. And your name over there, Mr. We have Sean Twin Bridges. Can you tell me your name?
Yes, Sean Fries, Twin Bridges Enterprises.
So, guys, I read this. Mr. Harris, do you agree there should be a stay?
No, I don't, Judge. Judge, this is the funny thing about this is there is no legal basis why the defendants should be entitled to store these trailers on my client's property. They have no lease, they have no rights. I did a 30-day termination of any right to keep that they may allege they have, but they have basically. They rented the trailers to another party. The trailers got stored on our property. We terminated everybody's interest. We just want the trailers off the property. And
Why shouldn't you have to take them off, Mr. D'Onofrio?
Well, Your Honor, if there had been no motion for reconsideration filed by Mr. Harris's client in the pending circuit court case matter, I would certainly agree with the court. However, what happened is that, and I put this in the motion, but I'm going to try to be brief, is that an order came down from the circuit court in that Danu Enterprises, Inc., which is one of the many entities that is owned by the same principal as Trenton Associates and another company called 1200 6th Street. That order said that the trailers were supposed to be emptied and returned to my client within 7 days. Mr. Harris's client in the circuit court action in which he represents that client and Danu Enterprises, Inc.'s attorneys both filed motions for reconsideration staying the enforcement of that order. And frankly, Your Honor, if it's such that they want to stay the enforcement of that order, and I think that the court would be within its power to at least grant a stay in this case. Because frankly, if they had complied and emptied the trailers, we wouldn't be here today. But I didn't ask for a stay of that order in the circuit court. And we're talking, Your Honor, about a $50,000 to $60,000 question in that if my client is forced to pay for the removal of these items from the trailer, then that's a cost that has to be borne by my client rather than Danu, who's already been ordered to do it. But there's the secondary issue of the liability associated with disposing of personal property that doesn't belong to my client. And the circuit court's order had resolved all of that issue. But now they've asked for a stay, both the defendants who are owned by the same principal. So I think that the court should stay this. I hate to use the expression, what's good for the goose is good for the gander. But the issue is that I didn't ask for that stay. And now I think my client would be at a severe prejudice and face liability, frankly, if he's forced to remove these trailers and remove the property that's in them, I should say. And we're talking 44 trailers, Your Honor, that are 53 feet long each. And there's a lot of stuff in those trailers.
And Judge, so it's clear, my client doesn't care what he does with the trailers as long as they're off his property. They have no right to, there's no legal basis by which they have a right to keep those trailers on my property. Period. End of story. They have no lease, they pay no rent, I don't care what happens to the contents of the trailers. My client doesn't care, but he has every right to say, get the trailers off my property. They were served with a 30-day notice to quit. That basically terminated whatever they wanted to allege they had. And they don't have a written lease. They haven't alleged a written lease. They basically have no right to store the trailers on our property. We don't care what happens to the contents. We just want the trailers off our property, which is what they stipulated to do. They've already got property elsewhere. They started to remove the trailers. And then the circuit court acted, so they used it as an excuse to say, we're not going to remove them anymore. They need to get the trailers off our property, which is what they agreed to do. We were kind enough to give them 60 days to get the trailers off the property.
All right. Anything else, Mr. Donofrio?
Yes, Your Honor. The March 24th, 26 order in the circuit court, the one I keep referencing, that order actually says that Danu was ordered not only to, Danu being the brother entity of the plaintiff in this case, is supposed to not only empty out those trailers at its own expense, but it's also supposed to return the trailers to my client. That's in the order. That's language in the order. But by filing a motion for reconsideration, they are now, in a sense, keeping the trailers. So they can't, on the one hand, argue, well, we want them gone, but we also want to stay enforcement of the order where we're supposed to give them back to you in the circuit court. And Mr. Harris, on behalf of Trent and Associates, filed the same motion for reconsideration in that circuit court case. So with all due respect, I think he's talking out of both sides of his mouth in that we want them gone, but we filed a motion saying we're keeping them because the court order says to give them.
Here's what I'm going to do. I'm going to ask Mr. Harris, you're going to prepare an order. Defendant shall vacate on or before June 12th. And plaintiff may file an application in order for eviction on or after June the 15th. That will give you an opportunity to go to the Wayne County Circuit Court and ask the Wayne County Circuit Court Judge Manette Berry to stay this action. So you better get your motion in. So I'm going to do that. If I don't have an order staying this action by June the 12th, I'm going to sign the application in order for a writ on the 15th or whenever it's presented by Mr. Harris. Okay?
Thank you, Your Honor.
Your
I
Honor,
don't care. Go ahead, Mr. Harris. I'm sorry.
just so I'm clear, so the order shall state the trailers shall be removed by June 12th, and if not, an order to evict can issue on June 15th.
Correct.
Okay, thank you, Judge.
Submit that over here, gentlemen, and have a good day. Thank you very much.
Thank you, Your Honor. Mr. Freese, I'll talk to you after.
Thank you. All right. Do I have Ms. Schlussel? Ms. Schlussel. Okay. I want Ms. There you are. Stephanie Nicole Calgar, 26B719107. Ms. Schlussel, your name?
Deborah Schlussel.
Ms. Calgar, your name?
Stephanie Calgar.
And Ms. Cahalan.
Claire Cahalan.
All right, Ms. Schlussel, what have you decided to do?
Your Honor, after discussing this with Ms. Calgar, she has decided, and we have mutually decided, that I will withdraw as her attorney, and she would like to go back to Mr. Gonick if that is possible.
And you agree to that, Ms. Calgar?
Yes, Your Honor.
All right, so I'm going to go ahead and grant that request. I'm going to ask you, Ms. Schlussel, to submit a stip order, and you should CC the prosecutor on that, indicating that you are, that the two of you mutually agree that you will withdraw as her attorney in this action, and then I will reappoint Mr. Gonick. Can you get that into me today, please?
Your Honor, I am in court all day and I'm in Lapeer.
Can you get it to me tomorrow?
Yes, absolutely. Maybe even tonight.
Okay, so we'll get that. Lisa, in the meantime, go back to MIDC and tell them that Ms. Schlussel is going to withdraw, and we are going to have I'm assuming they're going to have Mr. Gonick reappointed. And you could just set it next week then, Ms. Calgar. So you're to be back here next week at 9:30, and we will have next Tuesday, May the 12th, and we will have Mr. Gonick back here at that time. But again, Lisa, you're just going to have to confirm that MIDC is going to go ahead and appoint him again, okay?
Okay.
Anything else, Ms. Galen?
No, Your Honor, that's all.
Anything else, Ms. Schlussel?
No, Your Honor. Thank you.
Anything else, Ms. Calgar?
No, Your Honor.
Okay, have a good day. We'll see you guys here next week, or at least a couple of you. Thank you.
Oh, Your
Bye.
Honor, Your Honor.
What?
There's one quick thing I wanted to ask the court. So it's a technical issue. Ms. Calgar was given a map of where she's not to go, and that map is in Colorado.
Hang on. Map of where she's not to go.
Yes, so pursuant to the tether that she has, she's not allowed to go anywhere near the complaining witness. And
Does the complaining witness live in Colorado?
No, Your Honor. Your Honor, I've been in touch with the officer in charge on this case, the OIC, and he has a contact for me to be able to talk to the tether unit to get that figured out.
Detective Morrison, are you on this?
Yes, Your Honor. Yes, Your Honor.
Start your video, please, and tell me your name.
Detective Sergeant Morrison, Brownstown Police Department.
So tell me what's going on. I don't understand. I just ordered not to be released until fitted with a GPS tether, not to be within 2 miles of the victim, her residence or place of employment. I don't understand what in the world Colorado has to do with this.
Nothing. No, I don't think anyone knows, Your Honor.
Well, did the tether unit say she can't go to Colorado? Said it like that?
That's what we're being told.
Yeah.
Is that true, Ms. Schlussel?
yes, Your Honor, I've looked at the map. It features a freeway or a highway that's an interstate in Colorado that does not touch
Listen, this is
Mississippi.
what we'll do. Lisa, send the commitment or the minimus back to the tether unit and tell them to check into that, and highlight my previous order on the minimus that we sent them and ask that they figure it out, but she shouldn't go to Colorado or any other place until we get this resolved. She's not planning to go to Colorado, right?
No, Your Honor, the reason I bring it up is that you ordered her not to be within 2 miles of the complaining witness. She does not want to violate that. And so if the Colorado map is not correct, we would like to know where it is she's not supposed to go so that she does not violate unknowingly.
Where does the victim reside? Do we know that?
I do know that, Your Honor. I would not like to say exactly where she lives.
I get it.
Yeah.
Look.
Is it possible to say the city?
Well, you want me to proceed? I will. Let me just have them send it back the minimus. And Ms. Cahalan, you and Detective Morrison, I'm going to ask you to figure this out and talk to the tether unit. And unless the victim's in Colorado, that's silly, but it doesn't sound like she is. So, Ms. Calgar, let me just check something. Unless somebody can think of something else I can do to resolve this, I don't.
Judge, I have a contact at the tether unit. I'll get a hold of them.
Okay.
and send it
And
all
talk
over.
to Sergeant Morrison and the APA and make sure that's taken care of. Will you please, as soon as you can, Lisa?
Yep, I'll take care of
Thank
it.
you. Thank you very much. I'll see you next week, Ms. Calgar. Thank you. Thanks, Ms. Galen. Thank you.
Thank you, Your
Detective.
Honor.
Thank you, Your
I
Honor.
know.
Thank you, Your Honor.
Charles Ellis Bonds the third, 26M 658-175.
Yes, sir.
All right, so that was your name?
Charles Bonds. By Charles.
That was a rental car?
Yeah, yes, actually, it was a semi. It was a rental.
All right, so you're gonna plead impeding traffic, right?
Yes, sir.
All right, and that's a civil infraction. You understand that. It's not a misdemeanor, right?
Yes, sir.
Okay, to that charge of impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted. Original charge dismissed. So we're dismissing the misdemeanor. 150 is your total. You can go down the hall and pay that, and you're all set.
Can I pay on the phone later on today?
Yeah.
I was rushing.
Yeah, no problem. So I'll just give you till 3 o'clock. Is that good?
Yes, sir.
So you pay that by 3 p.m. today.
Yes, sir.
Any questions otherwise? Have a good day. Good luck. Thank you.
Thank you.
On behalf of the people of Haiti, congratulate.
And good morning, Your Honor. May it please the Senate report, Stephen Colbert, right, P52354, appearing on behalf of Mr. Kennard.
So, and Mr. Kennard, your name again.
Good morning, Your Honor. Stephen James Kennard.
So you wrote set jury trial. She's moving to dismiss on some basis.
Yeah.
Go ahead and proceed. What is your basis for a dismissal now?
Yes, Your Honor. Today is the time for pretrial in this matter. We appeared previously for a pretrial. At that point, we had anticipated setting the matter for trial before, Your Honor. However, we continued pretrial negotiations. We provided exculpatory evidence to the government on my client's behalf. I appear today for purposes of, I'm assuming pretrial negotiations. It was brought to my attention that the people have reached out to the complaining witness. As of today, the complainant is not responding. We have independent information that there may be an issue regarding the complainant. I don't know. I know that the people have not been in communication with the complaining witness as of today.
Did the judge order you to have the complainant here, Judge Hessen, when she had this case?
No, I do not recall. I don't know if that is in the file.
She didn't write it down.
I think that the adjournment was placed on the record without any before, just through the file and the signature.
So what is the basis for the dismissal?
The fact that the people have not been in communication with the complaining witness. They reached out to her, Judge. She's not responding.
Here's what I'm doing. We're setting this for a jury trial and a final pretrial. And I'm going to tell you the complaining witness has to appear.
Thank you.
So let's do this. We're going to set it for a jury about 5 or 6 weeks out on a date. Ms. Holloway, your eyes are already going up. You're going to tell me you're not available until November.
The only trial date that I have coming up is June 5th, which is a Friday. So, and anything after that, I don't have anything.
Oh.
I leave until August.
Perfect.
26th at 8:30.
What's that?
June 26th at 8:30.
That works.
Oh, yeah, I'm gone the 12th.
Yeah, 19th is a holiday.
Right. Okay. You're good? June 26th?
Judge, I can make that work, June 26th.
June 26th at 8:30.
Judge, is it possible,
Now I'm gonna have a final pretrial.
is it possible to come back sooner than later for the final?
Oh, yeah.
Can we come back?
Well, I'm gonna give them a little bit of time to get the victim or the victim complainant to appear at final pretrial. Any reason you can't get her here by the 19th?
The 19th would work.
19th at, I have an appointment and I'm gonna be in a little late that day, so I'm scheduling everything later. So let's make it at 10:30 a.m. Victim to appear. So you're gonna have to subpoena the victim to appear. If the victim doesn't appear, then I'm gonna dismiss the case. We'll talk about jury instructions, assuming there's no resolution, the final pretrial.
Was that May 19th or June 19th?
May 19th,
May
2 weeks.
Judge,
Okay, anything else?
nothing further, to appreciate the court.
Have a good day, everybody. Thank you. What else do I have out there? Who'd you say
Mr.
your lawyer?
Dox.
What's that?
Mr. Dox is in a breakout room.
Did you say your lawyer is
Prosecutor.
again, sir?
Sean Smith, sir.
Okay. John Smith. What time was that scheduled, Lisa? 10?
Yes, that's the attorney that called and said he was running a little late.
9:30. Okay. I have nothing else ready, right?
Not on Zoom, no.
Did I set the 11 o'clock for a reason?
I do not recall. I'm going to assume the attorney wasn't available.
This courtroom moment starts like a normal hearing, but within minutes, it turns into a serious discussion about ethics, loyalty, and conflict of interest. A woman appears in court connected to a larger criminal case involving her husband. At first, it seems routine. Another adjournment, another scheduling discussion. But then the prosecutor raises a major issue that changes the entire atmosphere in the courtroom. The problem? The same attorney representing the husband is now representing the wife too, even after the wife testified under oath in a way that directly conflicts with statements she previously gave to police. According to the prosecutor, her testimony in court completely contradicted what she originally told investigators about serious allegations involving criminal misconduct. That's when the judge steps in. Calm, careful, but clearly concerned. He starts questioning whether this attorney can fairly represent both sides without creating a dangerous conflict. Because if one client's defense harms the other client's case, the entire process becomes compromised. Then comes the key moment. The judge openly says it certainly sounds like there's a conflict. And suddenly, the attorney herself realizes the risk, not just for her own position, but for the defendant too. In the end, she agrees to withdraw from the case to avoid creating bigger legal problems later. Because sometimes in court, the biggest issue isn't guilt or innocence. It's whether the system itself is being handled fairly. So here's the real question. If a lawyer believes both clients are on the same side, should they still be forced to step away when a conflict appears? Or should the clients decide for themselves? Like and subscribe for more real courtroom moments.